All right, here we're continuing on with our political series, Conversations with Keith. Have Jeff Dean, County Attorney, has been around, a very familiar face in Pendleton County throughout these times, and seeking to return to the office of Pendleton County Attorney and represent you. We've kind of talked before and talked that this is a wide variety. This is going to be a very informative session because there's a lot of things people don't know, including me, don't know what a county attorney does. Right. And so, but before we get into all that kind of stuff, we talked about you're a graduate of Pendleton County?
No.
I'm sorry.
My wife is.
Wife, that's right.
I'm a graduate of Bellevue.
Bellevue. And then NKU?
NKU for undergrad with history and political science majors, and graduated with honors, won awards for being outstanding student in the public administration and political science department. Then went to law school at UK College of Law. And
that was during late 70s, early 80s?
Graduated college in 78, graduated law school in 81.
And that's some good Kentucky basketball that you got to. Kentucky football was good at that. Was that Art Still's days?
No, I think he was 77.
Okay, just so right before you.
Just before I got there, I got to see him. First game I ever went to was Kentucky, Georgia, and I got to see Herschel Walker run wild.
Oh, wow, yes.
So
now Art Still's daughter, or sister, Valerie Still, was playing for the Lady Cats at that time. One of the best players in Kentucky history.
Right.
And so you're there for Sam Bowie, Melvin Turpin.
Twin Towers, yeah.
Skywalker, Kenny Walker. Probably as a freshman,
yeah. I remember Bowie and Turpin, and that bunch was really fun to watch.
I would say so.
And you'd watch in the school newspaper, you know, the recruiting when they actually were recruiting Sam Bowie and Ralph Sampson, and almost got Sampson. Could you imagine how good they'd have been with those guys?
Absolutely. I remember my dad talking about that. That was back in the day. You know, now you've got these recruiting things on, but that was back in the day when the Street and Smith came out.
Right.
If you were a basketball fan, boy, you got that Street and Smith and you devoured every page of it.
Yeah, that was this. I read the Kentucky Colonel, I think was the campus paper back then that had all the recruiting news in it for the campus folks. I couldn't afford the real papers. I'd read them in the law library.
What college student can afford those?
That's for sure.
Hey, while you were there, of course, we're going to talk about it a little bit because I know there's so many different things you do as a county attorney. As you study to become a lawyer, do you all have a set curriculum to go to? Do you have specializations that you can choose to emphasize? You know, kind of what's that education like?
Back then, things have changed a lot over the years, but I know back then at Kentucky, there were certain courses you were expected to take your first year. You had to take civil procedure, criminal procedure, evidence, criminal law, property law. You know, there were some basic types of courses, early contracts, torts, some of those types of things that everybody was required to take. And then as you progressed on, you could start picking the kinds of courses that you wanted to take, you know, as you move through your career. So, sort of like college, you didn't necessarily specialize in an area, but you had more diversity of classes to take and things to focus on.
Were there fields or areas that you liked? You liked going to that class?
I didn't like much about law school. That was a different experience. I mean, it's different. You know, college came kind of easy. I hate to say it, but it you know, because it was political science, history, things I just really, you know, loved and just devoured. But law school was a different beast. I mean, it was just different kinds of courses, different types of teaching. Professors were different. I kind of enjoyed the property law kinds of things, and the criminal laws had some, you know, some of the, you know, some top-notch professors. Some of them were the folks that helped write our Kentucky Evidence Code, write the Kentucky the Criminal Code, and so forth that were teaching at UK at the time. You know, you had a lot of folks that were really involved, so you got to learn from the guys that wrote some of the code, or were very instrumental. Dean Lawson, Bob Lawson, wrote a lot of the criminal commentary. Even today, if you look at the commentary on the criminal code, of what the statute is supposed to mean and what their intent was in writing it. He wrote much of that commentary. Well, he taught criminal law. He also wrote a lot on the Kentucky Evidence Code at that time, and he taught evidence. William Fortune taught criminal procedure, also deeply involved in it. Louise Graham taught family law and was one of her books early on was the book that attorneys would go to keep up on newest issues in family law. So, so it was a good experience, really. I mean, it was unlike anything. The first semester you take, you're kind of in shock, and then you adjust to it and move on.
So, as you look to these books, these laws and such, to look at cases and those kind of things, the people who wrote, your understanding of those were enhanced because the person who wrote it was the one who taught you.
The ones that at that time were very instrumental in writing were professors at UK. Yes, so that was. I know early in my career I used to love to say, well, according to Dean Lawson, when I'd argue an evidentiary report to the judge, and some of our judges also went there, knew who I was talking about. So this is what this rule means, Judge. And so it was good to hear from those folks.
I had a similar experience at Berea College. I took a African American experience class in the 1960s, and Dr. Cleo Charles was the professor who had walked in the marches with Martin Luther King.
Right.
So he didn't teach us from history books. He taught us from standing right there 20 feet away, experiencing. And so it was so cool having that firsthand experience of not reading it in a book, but just having somebody tell me what actually happened.
Yeah.
So a similar experience of what you're having.
Right.
Well, let's go ahead and get started. This first question is going to be why because I know it's so varied. What are the county attorney, and most of the people out there don't know what a county attorney does. They see Law and Order, and they see what's Jack McCoy, and they think that's a lawyer.
Yeah.
But for a rural county attorney, what are some of the responsibilities you have?
Well, I don't watch Law and Order. Denise, my wife, loves it. I go nuts because whenever they make objections, I'm jumping up saying, you can't do that. I always say the best TV law show was Night Court because it most resembles district court to me.
I love that show.
Yeah, I did too. But there are a lot of duties. Everybody thinks of the prosecution duties. I mean, that's what everybody thinks of first. And that is, probably the largest part of what I do is prosecuting misdemeanor offenses, which are traffic offenses, driving under the influence, minor assaults, fourth-degree assaults, where there's no serious physical injury, but just a physical injury of some sort. Someone punches you in the nose, you get a bloody nose or a black eye.
Gotcha.
Or maybe you don't even have a visible injury, but you've got some soreness and pain from it. That's an assault. Now, if you use a weapon or an instrument, hit somebody with a crowbar, or you break multiple bones, then it becomes a felony. It's a higher degree. I don't prosecute those. I have the initial prosecution of that through a preliminary hearing stage, but felonies go on up to the Commonwealth Attorney and are tried in circuit court.
Is that personal choice, state rule?
That's the law.
That's law.
That's law everywhere. Felonies are in circuit court. Misdemeanors, traffic offenses are in district court, which is where my jurisdiction is. So
district court is Custer and
that's Judge Custer. That's it.
And then
circuit court is Judge Delaney.
Judge Delaney. Yes. Okay.
And then there's the family court, which is a branch of circuit court, if you will, or a division of circuit court, and then that's Judge Fryman.
Okay.
So,
now, on the assault case, what kind of time are we talking about? If somebody was found guilty to the fullest extent of the law, just to kind of give an
Class A misdemeanors, a maximum that anyone can get on a Class A misdemeanor is 12 months in the county jail. And it doesn't matter if you commit one Class A misdemeanor or 30 at the same time. The most you can get is 12 months. You have to run them all concurrent. You cannot give them 1 year on assault, 1 year on a criminal mischief, and 1 year on a theft, that they all happen together and say, now you got a total of 3 years in county jail. You have to, by law, 12 months is the maximum on a misdemeanor. When you get into felonies, then you're talking penitentiary time, and they can stack those types of charges. You may get 5 years on one charge and 5 years on another, and they can run them consecutive for 10 years. But by law, the most you can get on the most serious misdemeanor in Kentucky, the most serious offense that I can prosecute is 12 months to serve in the county jail at the county expense.
Gotcha.
Not the state expense.
So let's talk about a couple burglary. Is that a felony or a
Burglary is a
misdemeanor?
felony.
So felony.
There's 3 degrees of burglary. They're all felonies. Burglary is essentially entering or remaining unlawfully in either a building, a residence, with the intent to commit a crime. And if you are armed with dangerous weapons or explosives or steel guns, it moves it on up to a first degree burglary. The lowest end of the spectrum that's similar is criminal trespass, where you go on somebody's property, entering or remaining unlawfully on property of another or in a building of another. Those are all misdemeanors. So it's sort of the difference is, did you go in to commit a crime or did you just go into the building? You know, didn't really intend to commit a crime, but you walked into somebody's house and sat down on their couch.
So if I go to one of the vacant buildings down here, that would be a criminal mischief.
Or criminal trespass.
Criminal trespassing.
Yes.
Now, if I go in there and break out windows, that becomes criminal
Then
mischief. Both are still misdemeanors.
Well, no, if you go into that building and commit another crime,
okay.
so if you go into the building and start taking a sledgehammer to the walls, now burglary, because you went in to commit a crime with the intent to commit a crime. Nobody has to live in it. If you do that, it's burglary third, because it's a building. Because it's not, building's an unoccupied house that nobody lives in. Just, somebody just happens to not be home, it's their residence, and that makes it burglary second, which is more serious. But if it's just an empty building, a barn, a garage, a storage building, a shed, those are all burglary third. If you go in and with the intent to commit a crime, you go in and steal a lawnmower out of a garage. Technically, that's burglary third, even if the lawnmower is only worth $10. Mm-hmm. It's a felony. So if you just go in, you're just hanging out, you're not supposed to be there. Like if there's a vacant building downtown and somebody goes in without permission and just stays in that building, that's trespass.
Okay.
And that's trespass.
Drug charges.
Drug charges.
The possession, the drug trafficking charges that we would see, what are those? Felonies, misdemeanors?
Can be both, depending on the substance involved.
Okay.
So if it's heroin, cocaine, methamphetamine, those types of charges, those are all going to be felonies.
Okay.
There are some lower prescribed medication you may have in your possession that are not the narcotics and things of that nature. That can be a misdemeanor. So
and that's possession and trafficking, either like possession of
some of the trafficking can be just even a misdemeanor, like trafficking marijuana can be a misdemeanor if it's under a certain amount.
Gotcha.
Like marijuana gets into, you can cultivate, you can possess, or you can traffic. And again, it gets in kind of what all the circumstances are and the amount. So 5 or more plants, cultivating is a felony. Less than 5 is a misdemeanor. So, we had that big bust here a while back with 500 some plants. That's a felony.
And so you might do the preliminary hearing
and I did.
But you're not going to be involved in the and that would be the state law that you're following.
Right, yeah, the Commonwealth Attorney, that I lose jurisdiction once, and I conducted the preliminary hearing in that case, had the detective there, the state police officer that worked the case. He came in and testified just for probable cause. And that's all that I can do is you testify, is there probable cause that a felony was committed, and is there probable cause that the individual that's charged is the person that committed that felony? If the answer to that is yes, it's bound over to the grand jury, and at that point the Commonwealth Attorney takes over and I lose jurisdiction. I'm out of the case. There are some cases they may call me and say, what's the real story here? What's what's your history with this fella, or whatever. And maybe ask me, just some background information if I know of something, if they're not familiar with them. But truthfully, once it reaches that level, I'm out of the case. I'm available if they want to talk to me. They sometimes do, sometimes don't, because, there's no need to talk to me. The person is charged with a crime. It's pretty clear cut what the charges are. They don't need information from me. But every now and then something goes up to them, and they'll look at, because some of them, are kind of close calls too, as to whether should it be a felony, should it be a misdemeanor. Technically, it may be a felony, but do we have a real prospect of winning this case? Is there some reason that, the Commonwealth Attorney might say that maybe we should not try this as a felony? And sometimes we send things up and the grand jury sends them back and indicts them on a misdemeanor. Pretty rare, but occasionally does. Normally they either fail to indict or they indict them on a felony, and then the Commonwealth Attorney prosecutes the case at that point.
Okay. Are there any other charges that a person, a non-legal person like myself, would see occur that is either falls in your realm or doesn't fall in your realm? We talked about burglary. I'm assuming robbery.
Well, robbery's a felony.
It's a felony.
You know, theft under $300 or under $500 is a misdemeanor.
Okay.
Theft over $500 is a felony. So theft, cold check. Someone writes a cold check for, $50 to one of our local merchants. That's a misdemeanor. Goes through me.
Okay.
Obviously, all the traffic offense like speeding, drunk driving.
When you said traffic, I was thinking drug trafficking. You're talking about driving traffic.
Yeah. You get a speeding ticket. That's in district court. You get a drunk driving charge, unless it's a felony drunk driving charge. That's in district
What's
court.
a felony drunk driving charge?
Felony is a fourth offense.
Oh, okay.
Becomes a felony.
Okay.
So, at that point, you've had your 3 shots in district court within 10 years.
Yeah.
Law just changed here a while back to make it a 10-year. Used to look back 5 years, now it's 10 years.
Wow.
So there's a lot of people that had some charges go off the record that suddenly came back on when the law was changed to 10 years.
Gotcha.
And but if you have 4 of those in 10 years, you've got a felony.
Okay.
And it has to be convictions. You can't be charged and acquitted, but if you're convicted of 3 DUIs and you get another one in that 10-year period, it's a felony.
And that would move on up to the
It goes up to the
Commonwealth. Who is the Commonwealth Attorney?
Doug Miller, and then
Miller.
Michael Laws is his assistant.
Yeah, I remember Michael Laws had him in class,
Right.
but I can never remember the main ones.
Yeah.
Doug Miller. Anything else? You said trafficking. I guess some child support. There'll be some non-flagrant support cases.
Some
that
child
would be-
support cases will be misdemeanors. I don't prosecute too many misdemeanor child support cases because I typically will you can also pursue them civilly through contempt of court.
Okay.
So I will try to do that as a rule. And the felony, when they hit that $1,000 mark and they're 2 months behind, you have to have those 2 elements. Then I can go after them as a felony. And so, I usually try to do the civil route first, keep
Okay.
that criminal charge off of someone's record, give them a chance to live up to their responsibilities. And if they are not going to do it, then, all right, we're going to charge you with a crime. We'll see you in big boy court is what I like to say. And, then if they're still not just horrendously behind, I'll try to work with them. Because if it's, if they're behind $1,500 and I send it up to circuit court, well, they're going to put them on probation or diversion anyway. Mm-hmm. And so since deal with the child support all the time, have ready access to all those records, I will often keep those in district court, even though it's a felony charge. I won't have the preliminary hearing. I'll keep those cases so that I can review them every month to make sure they're making their payments.
So if you send them up, you don't have that review. The court
Once
has
they're
it.
indicted, I'm out of it.
Okay.
The Commonwealth Attorney's Office will
Gotcha.
give them the information, but once they're indicted, I have no jurisdiction. Again, have no say in what happens. It's totally up to them. As I say, they will sometimes consult me, and we, had a working relationship over the years. Always been a good working relationship with whoever has been Commonwealth Attorney when I've been County Attorney. So we kind of know where we're at on things, and I know what's going to happen to them if they go up to circuit court on a child support case. As I say, normally it's going to be they're going to be put on probation, or they're going to be put on diversion and set up on a payment plan, and then they will watch that, or probation parole officer will watch that. But oftentimes they're not right on top of it in probation and parole. They've got so many other things to monitor. Whereas if I have them, I'll generally make them come back every month. And they'll be on the docket every month.
I know.
And
I type their names.
You see it
every month.
I know people say, well, we get tired of seeing it. But if I keep them on that docket, they're going to make their payment because they know when they walk into that courtroom, if they haven't made a payment, they're looking at going up to big boy court and having that felony.
P or S, 5 days or pay.
Well, that's That's
Yeah.
a non-payment of fine,
Yeah.
and it's where, you either pay the fine or you lay it out in jail at $50 a day. That's another thing our legislature came up with, that, if somebody has a $100 fine, they can go sit in jail for 2 days and then they don't have to pay the fine. I'm not a fan of that, because they, number one, they don't have to pay the $100 to the state. And number two, they're sitting there in jail 2 days, and that's costing the county $35 a day. So we pay for them to sit in jail, and they don't have to pay the fine.
So that's $170 that the county's out of money.
Well, the $100 would go to the state.
Oh, the state. Okay,
But it's $70 the county's out, because the state gives them that opportunity. And you can imagine somebody that's got several $100s in fine, how much that costs the county. So we try to get them to do community service or whatever, but that's one of the things the state legislature has passed into law, that they can be given credit for that. And just, some guys just choose to go sit, I've got to do 5 days, 10 days, I'll just go to jail for 5 or 10 days, then I don't have to worry about this anymore.
Yeah.
Some folks, and I have no control over that.
Yeah. Will Schroeder sat in that seat a couple weeks back, and he made a comment I'd never thought of before. We were talking about the drug issue, and there's a thought out there about taking possession off the felony list so it's not on the record.
Oh, yeah.
But one of the points he mentioned is, if it moves from a felony where the Commonwealth and the state is addressing it to a misdemeanor where you're addressing it, where does that cost?
Guess where?
Shifts to is to the local level.
There was a bill before the legislature this last time that was pretty much going to decriminalize most of your, I don't want to say decriminalize, but make most of your drug offenses misdemeanor offenses. Was going to make several other felonies misdemeanor offenses. It's going to make some charges not even misdemeanors, just going to make them a fine only offense. That was just horrendous if it had passed. I think.
What would that do to your office?
Well,
what would the workload be? What would be the cost of fiscal court on housing those prisoners?
Well, it's say $35 a day, and when that bill was pending, we were paying $50-some a day to Boone County. So, I have to be fiscally responsible with our taxpayers' money. If someone needs to go to jail, they're going to go to jail, and if they need to be there, they're going to be there. I don't believe in home incarceration and putting them on an ankle monitor. There are some rare circumstances we'll do that, because maybe somebody's got a medical issue that they're going to need treatment, and if they're sitting in county jail and they've got medical issues and need medical treatment, guess who pays for it? County pays for it. So there are some of those occasions I'll keep somebody out of jail, or I'll agree to home incarceration. But if someone truly needs to sit in jail, I'm going to let them sit there. I'll still hang more probated time over their heads, for like a repeat offender. Let them go serve some of what they should have served, or what could have served on the first, and when they get out, they've still got that hanging over their head to try to encourage them to quit doing what they're doing. Because otherwise, if you say, well, go serve 30 days, and there's nothing holding them over their head when they get out, they serve their 30 days, they're out, and you got nothing on them except starting over. Whereas if you give them 90 days, go serve 30, and they sit there and they serve their 30, they get out, well, they've got 60 more days for 2 years, that if they mess up again, they're at risk of going to have to serve those.
So what you're saying is, they go to serve 30 days and it's a 30-day sentence, then you're done with them after 30 days. But if you get them a 90-day sentence, they serve 30, same amount of time they're serving.
Probate.
But you can watch what they're doing for the next 2 years, and if they mess up again, they get those 60 days.
Plus whatever else you might give them on the other. So, and 2 years is the maximum in district court. That's the longest period we can put somebody on probation.
Okay.
So most of the probations are for 2 years that we do.
Okay. How many times, and I know if you give me an exact figure, you're going to really impress me, but how many times does somebody violate their probation and have to go back?
It's not terribly often. We've got a few folks that you've typed their names in, I'm sure.
Probably had them in alternative school.
That do that. And there's some that for year after year after year, normally it's been alcohol related when I've had a lot of those. And they go out, they get drunk, they create a ruckus. They don't oftentimes hurt anybody, but they're creating a ruckus. And sometimes the police have taken them home and said, look, stay home, behave yourself. And then an hour later, they're back out on the street or down at somebody's house, pounding on the door, and they go in. Well, some of those folks I put in for 90 days or 6 months because they've been so many times repeating. But, again, they're going to be the kind of people that you put them in 90 days, they get out, and, they're alcoholics, number one. So, you can lock them up for long periods of time and spend a lot of money to keep them locked up, county expense, and they're still probably going to do it again anyway. So,
and it's more alcohol causing those issues than controlled substances?
Those are, I think, a lot of times are alcohol. I mean, we do have some controlled substance type things, so, a lot of those, they're public intoxication where they're under the influence of something other than alcohol. We have alcohol intoxication where you're under the influence of alcohol, and we have public intoxication where you're under the influence of something other than alcohol. Those folks, my normal recommendation is like 90 days in jail, but it's probated for 2 years on the condition you go get a drug assessment and follow any treatment recommendations.
Okay.
So we try and, we can lock them up for 90 days. That's not going to solve anything. Whereas if we have that over their head and they go at their expense and get that assessment and then get the treatment, sometimes maybe we can get them on the right track. Now, some of them later on are going to show up again with possession of heroin or something, and now they've got a felony and they're going to go to circuit court. It's very rare that I'll amend a felony charge to a misdemeanor drug charge. There are a few occasions because there's some that may be a very small quantity, the person doesn't have a record, and we have a drug court program now in district court. And sometimes we'll amend that to a misdemeanor and refer them to drug court, which is really a difficult process for people because we review them twice a month. Those folks have to come to court, plus they have to go to all the meetings, they have to meet with the drug court staff, they have to be drug tested. And oftentimes, when you have a drug problem, you fail and they get them into treatment. Sometimes short term, a lot of them end up in long-term treatment, which is the most successful treatment is long-term. But it's a process.
What's long-term?
Long-term to me is at least 90 days, but you'll see some 6 months to 9 months to 12 months. And, it takes getting people in there. And then the real key is when they come out, getting them away from who they hung with. We've got one gal in drug court now that, she went to a short-term treatment. Problem she had was when they released her, she had to get home. Who'd she call? Yeah. And she used again. She's sitting in jail now. The plan is long-term treatment till we get her a bed in long-term treatment. She's there. And,
sometimes some of your choices is about trying to solve the problem instead of addressing the behavior that resulted from the problem.
And when they get into drug court, they have to plead to the maximum penalty. Okay. So if they plead guilty. They have to plead guilty, and in most cases they get 12 months in county jail hanging over their head. That is probated on the condition they successfully complete the drug court program.
Okay. So
if they fall out of the drug court program, if they just don't successfully do it, we've had some that have absconded. We've had some that have just said, I can't do this, it's too hard. Then we move to revoke their probation. But treatment, you can lock people up. And I don't have a problem locking people up, but all that does is dry them out. And in some cases, it might encourage somebody, to not use because they don't want to go back to jail. But in a lot of cases, all it does is dry them out. They come out. They've got no tools to try to, to help them deal with their problem. They've got no contacts, no resources. So they're back on the street, and they're going to go back to the same folks they always hung out with. And, I sort of think of just like an alcoholic. If you know an alcoholic, if they hang around, if they go to an outing or event and people are drinking, they're going to drink. Well, people that have substance abuse problems, same deal. If they get out of jail and they go back with all their same buddies, doing all the same stuff they always did, what are they going to do? They're going to use.
The normal person.
Most of them are not going to have the willpower on their own. So, that part of it
And
is
they
trying
may
to teach them.
They may have the willpower 99 times out of 100, but it's that one time
Yeah.
that ruins it, that they didn't have the willpower that one time.
Yes, and then what you also see is sometimes someone's in jail for a period of time, and before they've gone in, they built up a certain tolerance to the substance, and when they get out of jail, that tolerance is gone. But whereas they maybe started out using a small amount, it took more and more to get on that high. Well, when they come out, they start, they go back to that same large amount for that high, and it kills them.
Wow.
I mean, that's a lot of deaths are people that have dried out and then come out and use the same amount that they were using when they quit.
Yeah.
That the tolerance is gone, and it's it just kills them, and it kills a lot of people, and it kills a lot. I mean, I know attorneys that have lost children, grandchildren, a lot of good people, what we call so-called good people, business people, that their families have been ravaged by this. And I've heard people say, well, I heard Ohio's got a thing on their drug stuff, and one of the guys that are, well, it's kind of a victimless crime. They want to do these things to themselves. It's not victimless. Those folks have children. It's a cost to the society, and and if they have children, now grandma or grandpa's got to take care of their kids. There are really very few what I'd call victimless crimes. There are a lot of repercussions. So, just locking somebody up, sometimes people have to be locked up, and that's the only solution. But, in another situation, you try to get somebody some help so that you don't have to lock them up. Because if you lock them up, you're paying for it.
Yeah.
It's your dime. It's easy to say lock them up, but 12 months, $35 a day. I haven't done the math on it, but it's more than I want to pay.
And when that person gets out, you put something on their record that might prevent or hurt them from getting a job that they just may transfer from one government department taking care of them to another government department. Well, we talked about drug court, prosecution as far as responsibility. I know from personal experience, because when I was alternative school teacher, you dealt with juveniles a lot.
I do juvenile court, and there's sort of two different branches. If a minor commits a crime, what would be a public offense, the theft, the whatever, the theft, assault, harassment, whatever that crime may be, and even felonies, they go through a process where it's prosecuted in juvenile court for, much like a criminal case. You change some of the terminology. The options of what you can do to children are less. The law has changed. Now they have mandatory diversion where they're given opportunities to not even come to court. They go through the court designated worker, and they go through those programs, and they basically get 2 or 3 strikes at that before they come to court even. So we don't get as many in court just because the law has changed to give them better opportunities to keep their records clean. Locking a child up and putting them in jail is very difficult. In some cases, it's illegal to put them in jail.
Really?
Because we have another set of juvenile that's in family court that's what they call dependency, neglect, and abuse, where the child is the victim, if you will, but the parents are there because they've neglected their children, they've abused their children. Or sometimes you've got children that the parents know it's the parents' fault, they just can't take care of the child because the child has disabilities or psychological needs that they can't get them the treatment they need. They can't, just take care of that child because of it. So that's a dependent child. It's nobody's fault. It's beyond their maybe financial ability or just beyond their ability to take care of this particular special needs child. So those are done through family court. So I'm involved in all of those cases. Sadly, and when I get back to my victimless crime statement, many of the neglect and abuse cases that I encounter, I'd say almost 90% of every docket is one or more of the parents or their boyfriend, girlfriend using drugs in front of kids. So there's your victimless crime. There's no such thing, because now you've got children that are needing to be removed from those homes and to be cared for. And who's going to do that? It's either going to be the state, it's going to be a family member, a friend. Somebody's going to have to take care of those kids until mom or dad get their act together And, you know, the law has changed recently that if they don't get their act together quicker, those children can be permanently removed from them and sadly in some cases put up for adoption, or at least the parent permanent custody can be granted to someone else, and the parent then has to figure out if they're going to be able to visit or whatever. Their rights weren't terminated,
Mm-hmm.
although as I say, at some point a lot of the parents' rights are being terminated quicker.
How many days per week or per month are you actually in court?
That varies.
And not fiscal court, regular court.
That varies. Every Tuesday is district court.
Pretty much the whole day?
No, usually mostly just the mornings.
Okay.
Just the mornings anymore. Sometimes it goes into the afternoon, but mostly on every Tuesday morning. I have regular the criminal juvenile court meets once a month. The family court is twice a month.
Okay.
But, and here's the rub on family court with so many of the things, I have a lot, and even with juvenile court, a lot of emergency hearings. Whereas I may walk into the office one morning at 9 and they say, oh, we just got a call, you've got to be in court at 10.
Okay.
Because the cabinet had to go out last night and remove a child. And usually I know that the removal was taking place because I'm the guy they call in the middle of the night and say, we need some paperwork, we need some orders to get this child removed from this harmful situation. And when that happens, within 24 hours, you've got to have a hearing to a temporary removal hearing to make sure that the child, doesn't go back home. Because, as a parent, you've got rights to your children, and government shouldn't be able to just come in and yank your child and keep your kid from you. So, there are some weeks I'm in court every day.
Really? Because of the special emergency? So the police officers decide they're going to do a drug bust tonight.
Mm-hmm.
They go in, they arrest mom and dad, there's 2 kids sleeping in there. Is that where the courts or the cabinet would come in, take the kids, and you'd get the 9 a.m. call that we have to have a emergency?
Yeah, sometimes. And I mean, the cabinet will come in, and if they've got mom and dad there, and mom and dad say, hey, grandma will take them, and grandma says, yes, I'll take them. And, they'll do a safety plan that allows, at least temporarily, to let the child go without the emergency.
Okay.
And then they'll still file a petition, and then we'll ultimately get a temporary custody order, but we don't have the emergency because parent has said, I'm gonna place this child, I'll let this child go with a responsible adult that can take care of the child. But sometimes you just don't have that. And sometimes we've had kids that have been removed from parents, gone to live with grandma, and then grandma gets caught up in a drug bust, and then it's, or that family member they want to send them to, they've got a drug history or an abuse history of themselves, and then we have to do the emergency when there's no appropriate person available to take the child. And sometimes just, getting somebody in the middle of the night to say yes, I'll take them can be difficult. So
prosecuting traffic and misdemeanors. I'm forgetting now. We talked about juvenile court, drug court.
Mm-hmm.
What other responsibilities?
I do disability hearings.
Okay.
Now, it's not Social Security disability, but it's basically competency. If somebody is unable to make informed decisions for their personal care or their finances or both, those are part of the duties of the county attorney. People will come to us and fill out a petition, and you run into that with seniors that have Alzheimer's or dementia. You run into it with people that have had serious head injuries, closed head injuries that now they don't have that mental capacity to do something, or to make those decisions. And then you have sometimes children that are born, that have had they're mentally delayed, low IQ. Down syndrome, severe Down syndrome, or whatever it may be, that when they're getting to be an adult, someone needs to be appointed to legally have the ability to make medical decisions for them, to make decisions of how they're cared for, to manage their finances, if any. Mm-hmm. So those are all part of my duties. And up until this year, those all had to be done by a jury trial. You'd process it through, you'd have a psychologist, a doctor, and a social worker evaluate them, file a report with the court as to where they thought someone needed to have a guardian appointed, and we would have a jury trial and have those things appointed. So I mean, and we would often do a couple of those in a day, 2 a day, and usually every couple of months we'd do a couple of those.
Yeah.
So I mean, I've done a ton of those jury trials over the year. Law has changed to allow in some situations the attorney that's appointed to represent that person to do a bench trial now. It's brand new law. So
From this last legislation session?
yeah, it just took effect this summer in July.
Okay.
So, but
Does that speed it up, lower the cost?
yeah, well, yeah, I mean, because you have to bring in 20-some people at $12.50 a head.
Gotcha.
And to have that jury trial. So when if there's a bench trial, we can schedule it quicker. The trial takes less time. And, you know, we've had a couple, and those are pretty much, you know, the attorney, everybody has to agree. This is kind of it's obvious.
Yeah.
I mean, you know, you may have somebody that's totally bedridden that has, you know, the IQ of a small child. Well, it's obvious what needs to be done. They can't take care of themselves. Someone has been taking care of them for years, but they've never had legal authority to do it. So now we need to get somebody to have that legal authority to make those decisions for them.
What do you do if there's no family member? Let's say, you know, there's a child and the parents have been taking care of them the whole life. The parent has now passed on. They were an only child. What happens?
If they're, you know, once they hit, if they're still a minor, obviously the cabinet, we go through that dependency type of thing.
But let's say
if they're an adult now and there is no family, or family has taken care of them, but now, you know, we've had cases where they're getting old.
Yeah.
And now they can't do it either. The state actually has a guardianship division where the cabinet can be appointed as someone's guardian.
Okay.
So we do that occasionally. We've got one of those pending right now, in fact. Just like that, we're just in court this past Tuesday on.
Okay. What about the grand jury? Do you have a role with the grand jury?
No role whatsoever you know, grand jury of course is a closed thing. If the Commonwealth Attorney requests me to be there, I can be there. Mm-hmm. I can only think of maybe 1 or 2 times since I'm Pendleton County Attorney that I've been asked to come in with the grand jury, because I have no jurisdiction there. I can't take a case there to the grand jury. Once I have that preliminary hearing, it's sent to the grand jury. We fill out some paperwork and send it up to Doug Miller's office and say, here's one we sent you. I mean, the clerks also notify them. They get notice that here's a case that's been bound over to the grand jury. From there on, it's theirs.
Okay.
And by law, I can't do anything with it.
Well, I knew on the grand jury I've gotten a couple of them to type up about flagrant non-child support, and I didn't know if maybe that was, but no, that's just where it's gotten.
Once it's a felony, once it gets out of district court as a felony, by law, I have no jurisdiction.
Okay.
I cannot go into court and prosecute it legally.
Okay.
You know, unless I'm appointed as a special prosecutor for the Commonwealth Attorney's Office, I can't walk into Judge Delaney's courtroom and prosecute a case, gotcha. Even though I may have started it. By law, I can't do it.
Is there any other areas, we talked about several there, as far as the legal aspect of it, of prosecuting it, any other roles that you have as far as those? Because I know you mentioned child support, and that's something that your office does, and I wanted to move on into that if there wasn't any other one.
We also do involuntary hospitalizations.
What the heck is that?
That's a situation where if we have somebody, and generally it happens that they might be in one of the personal care homes or something, but if somebody's suicidal, and the police don't get there and see that they're suicidal where they can try to take them direct to the hospital, but a family member comes in and says, this person's been diagnosed as schizophrenic, they've quit taking their medicine, they have to be a danger to themselves or others, so they're out now walking down the middle of 27, or they're doing this or that that's putting themselves in danger, or they've gotten really violent in the home, and now I'm in danger. They come to our office, fill out a petition, we send it up to the judge for an order for that person to be picked up, taken to North Key usually for a psychological evaluation, and if North Key determines that they are suffering from some mental illness and that they're a danger to themselves or others, to the public, they can sign off on that paperwork, which is then we send back to the judge. Judge issues an order, and that person can be transported and held in a hospital for up to 72 hours.
Wow.
And then when they're in the hospital sort of takes a look at it And a lot of times, after they get them stabilized, they'll release them. But there are occasions where they'll say, this person needs to stay in the hospital, needs to go to Eastern State. So then they'll pick it up, and then they'll
What's
try.
Eastern State?
Eastern State is the state psychiatric hospital
Where's it at?
in Lexington.
Lexington. Okay.
Yeah, so it's for mental health for adults.
Okay.
So they'll be sent there.
Okay. Now, child support, you mentioned earlier. What kind of role does the county attorney have in child support?
Of course, there's a role that's not prosecutorial, that is through managing the child support program. The state by law has to offer a contract to the county attorney to administer a child support program, and I've signed that. I've been doing it since 1989. Actually, even when I was not county attorney, Don Wells, I was his assistant. He said, you do the child support, and they delegated it to me. I was appointed as a special assistant prosecutor to do it, but basically...
So were you in private practice at the time, or working underneath him?
No, well, for a while it was, I had lost an election to Don.
Okay.
And he became county attorney.
And that was in '88?
That was it. That would have been, no, that would have been in 98. I took over in 89.
I'm sorry.
When I was first elected,
Yeah.
I was in, and then Don ran, and I lost to Don, and I was out 2 terms. For part of that, he just appointed me as an unfunded assistant, so there's no state funding, but I had the equality, I was accepted as a county attorney, assistant county attorney, for the purpose of running the child support program.
Okay.
And I signed the contract, and I administered the child support program under him for 8 years. And then when I was reelected, I've continued to do it. Basically every year there's a contract that comes out. I'm signed. I'm given a certain pool of money, and then with that money I have to pay for pay the staff, pay their health insurance, pay their retirement, pay for the paper, the pencils, everything that is used to run that office for the year. Mm-hmm. And I signed that contract, and with that, people can come. It's a free service to anybody. They can come and ask for assistance in collecting child support, and we can either establish child support by filing a civil complaint for support, or if they're in a divorce, we can intervene in that divorce case and ask to handle the child support process there. We do paternity complaints, so if a child is born out of wedlock and there's a father out there that needs to be made to pay child support, we can do that if the mother comes and asks us to help. Or if they're drawing public assistance of any kind, including a medical card, they're required to come to us by law to seek child support for that. So if a person is drawing a state check for the benefit of the child, they're automatically referred to our office electronically, and if they don't come in, we'll contact them, say you need to get in here, and if they don't, we can send something back to the state agency and say, they're getting a check but they're not cooperating. Or if they get a medical card, even if they're not drawing a state check, if they get a medical card on a child, they have to come into us to establish a medical enforcement order to try to get the father named, through a paternity case, and then get the father to order to provide insurance if he can. If he's employed and has insurance through an employer, to add that child to his, so that the child goes on private insurance instead of taxpayer-funded insurance.
Gotcha.
So we do those kinds of things. And then with the support, if somebody's not paying their support, we can file a contempt motion in family court as opposed to the criminal, which is what I typically do. Sometimes I have to do a contempt because if the mother does not live here, or the custodian of the child does not live here, if they live in another county, I cannot do a criminal charge because the venue lies in that county where the parent with the child lives. But I can ask that someone be held in contempt of court for not paying support. And again, I do it very similar to the criminal. They come in every month and meet with me. You'll see them on the first Monday of every month out there at the Justice Center. I'll be sitting in that glass, I call it a fishbowl, and they'll be lined up and they'll come in and I'll look, did you pay your money? Do you have some money? If you don't, tell me why, and tell me why I shouldn't take you and ask the judge to put you in jail. Or if it's bad enough, I'll say, this is your last chance. If you don't do this, I'm gonna file a criminal charge. It's that simple.
Yeah.
Take your choice. Either pay or we'll step things up a notch.
Do you see more grandparents? I know in the school district we've seen more grandparents raising kids. Back to the drug issue. Do Do you see more in that child support? Do both parents have to pay to the
Yes.
grandparent then?
And it's yes, we go after both parents, and it's interesting. You know, sometimes a grandparent will get the child and they'll go down and they'll draw a state check, and next thing you know, we're going after both parents, and that might be their little girl or their little boy, and they're, why are you picking on them? And it's like, you're drawing a state check. I'm paying to support your child. Every taxpayer in Kentucky is paying to support your child. We're going after your child, and we're going after his or her, you know, the other parent.
Mm-hmm.
We're going to go after both of them to pay the state back the child support that you're drawing. You know, occasionally they'll go down and say, well, then I don't want child support.
Really?
Yeah, because they don't want to go after their child.
I gotcha.
But it's like, I'm sorry, I know it's your child. I know you think that daddy out there or that mom out there is the worst person in the world, and they should be made to pay support, but your baby shouldn't pay for their own. It's like, it doesn't work that way. We, by law, go after them both. So if you're going to draw a state check, we're going to go after them both.
Wow.
That's the law. That's what we're required to do.
So we've talked about child support, we've talked about several courts, drug, all those kind of things. Any other responsibilities of the county attorney?
Well, there are a lot of things that the state legislature puts on us. We, in certain cases, are the attorney for various and sundry boards of the county boards or committees. We have duties, I think I mentioned to you once before, you know, we're supposed to go out and inspect houses of entertainment, whatever those are. You know, there are a lot of little things here and there throughout the statutes that we have duties to do. Delinquent tax collections. If there are delinquent tax, we can file lawsuits for folks that are not paying taxes. A few years back, the state initiated through the legislature a program where I can actually set people up on a payment plan, because maybe they can't pay their taxes. And what was happening was, tax bill was sold at the courthouse door, and companies were coming in and buying tax bills, and now they owned the lien on the property. And to get those liens released, they were just charging exorbitant fees. You know, a $500 tax bill might suddenly cost you $3,500 to get rid of, you know, to pay off. And sometimes it was hard to even track those people down to get a payoff, because they were reluctant to give you a payoff because they were drawing 12% interest on their money. So they're drawing 12% interest, they were drawing fees for attorneys, they were drawing, you know, all kinds of fees. And the legislature, you know, the county attorneys are one of the groups that signed a push that said, you know, we need to curtail this a little bit. And the legislature passed something to allow us to enter into payment plans with taxpayers, keep their property from being sold at the courthouse door. And so we set up plans. I usually give people 6 months, and once before the tax bills are sold, they can sign a contract, make monthly payments on their